Oyez, oyez, oyez. All persons having business before the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. This case before this court is Tuco Comics versus Walter White. Petitioners, would you like to reserve time for rebuttal?
Yes, please. 1 minute for my time and 1 minute for my co-counsel.
Great.
Thank you, Ms. Zarrett. You ready to proceed?
Yes, Your Honor.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Anna Zarrett, and I, along with my co-counsel, Billy Cosmopoulos, represent petitioner Tuco Comics. I will be discussing why an employment contract that assigns a copyright automatically makes a work for hire, and my co-counsel will be discussing why an independently copyrightable contribution is not required for joint authorship.
Ms. Zarrett, how was question 1 properly raised in the cert petition when neither the district court nor the 13th Circuit framed it in those terms? So how is it fairly presented?
Your Honor, it's fairly presented because those are the two issues that the circuit court did find, the district court did look to when determining that there was a work for hire. It relied on the employment contract and the presence of withholding of taxes. And those two factors, the contract especially, should control in a work for hire analysis. Now, in Communities for Creative Nonviolence versus Reed, this court established that when there's no contract, we know that the Reed factors apply, which are the common law agency rules. But it's not clear from Reed what applies when there is a clear, unambiguous contract, like the one here, which is on the record at page 14.
You say the contract is unambiguous.
Yes.
It's titled an employment contract, but the bulk of the consideration is a flat sum based upon the amount of comics sold. Why isn't it more like a licensing or royalty agreement than an employment contract?
Your Honor, it's like an employment contract because it states that Mr. White is going to will be employed by Tuco Comics. He received his salary in weekly increments. In addition, he worked for Tuco Comics for 2 years, and all of these factors, along with the fact that Tuco Comics exerted control over the creative output of the work, show that this was, in fact, an employment contract. And it's clear here, too, that Tuco Comics paid Mr. White to create a work that Tuco Comics would use. Now, under no reasonable interpretation would Tuco Comics be paying Mr. White to create a product that Tuco Comics could not use.
Well, the question isn't whether Tuco Comics could use it. The question is whether Mr. White retained any rights in it to be exercised at some future date, correct?
Yes, Your Honor. The work for hire provision, though, provision 4, established a clear provision that Mr. White was working as an employee and that he was considered, that Tuco Comics was considered the author for the purposes of the contract. Work for hire has a clear definition in Section 201B of the Copyright Act, which is that the initial interest of the copyright vests with the employer.
So how many different types of employees does Tuco Comics have?
The record.
For instance, do they have employees that get paid medical benefits, employees that do not get paid medical benefits, employees that get retirement contributions, employees that do not get retirement contributions? I mean, how many classifications of employees does your client have?
Your Honor, it's not clear from the record. It's not stated in the record. But here, Mr. White was clearly an employee based on the 4 corners of the contract. It established that he was working a regular job for 2 years, and while employee benefits here were not extended, he was working 30 hours a week, so it would not be typical to be providing employee benefits to a person that is working under full time.
Well, Tuco Comics really had no idea how many hours he was working, correct? He was working at a remote location with no supervision. He wasn't reporting to anybody at Tuco Comics or checking in or checking out. He could have worked 60 hours one week and 1 hour next week. How does Tuco know how many hours he worked at all? Maybe he came up with this on a weekend.
Your Honor, the record states on page 4 that Tuco Comics did meet with Mr. White and check up on his progress. So while it's not clear.
How many times?
It says occasionally in the record, Your Honor. So it's not clear how many times, but Tuco Comics was exerting control over Mr. White. And then moreover here, the legal question is whether this contract is what the court should look to first, before even getting to these Reed factors.
Can you have a work for hire if you don't have an employment relationship?
Yes, Your Honor, you can. Under Section 201B of the Copyright Act, it states that the parties can, in an express written agreement, assign a work for hire, and 3 circuit courts have relied on that statute along with this court's holding in Reed when they stated that courts first look to whether there is an employment contract and then they get to the Reed factors. And more importantly, this rule advances a basic tenet of copyright, which is to have a predictable and clear regime of ownership. So in Reed, this court rejected a control test to determine whether a person was an employee because it stated that test would require guesswork by the parties. And Reed is a 13-plus factor test. And to apply Reed in every situation rather than just looking to the clear language of the contract is bad for both publishing companies and for artists. If artists know, if they're put on notice that the contract controls in these situations, that the contract is what they need to negotiate about to determine whether it's a work for hire, artists are put in a better position because rather than having a backward-looking litigation like this that goes back and looks at 13-plus factors of employment, they know if the contract says work for hire, if the contract's an employment contract, that's all they need to negotiate on.
Well, Ms. Zaret, I'm confused about the Third Circuit holding on page 10. They held there was a material question of fact for purposes of summary judgment, whether the agreement was an employment contract, but in the next sentence, they go on to actually find that he was an independent contractor. Well, those are mutually inconsistent positions, aren't they?
Yes, Your Honor, they are. I believe that the 13th Circuit there was stating that it was not giving enough weight to the employment contract, and it was in effect ignoring the employment contract there and looking to the other factors. But the 13th Circuit should have looked to that clear contract. It's a 1.5-page contract that is very clear on its face what it is. It says,
well, the 13th Circuit said we conclude that White was an independent contractor. Is that a finding of fact, or is that a question of law? And what deference is this court required to give that statement in the opinion?
Yes, Your Honor. So the court reviews how the facts accumulate to whether he's an employee or an independent contractor de novo. And then the facts themselves are reviewed for abuse of discretion. But the legal conclusion from the facts here, which are undisputed by the parties, are reviewed de novo by this court and by the circuit court.
Are you suggesting that the Court of Appeal makes findings of facts?
No, Your Honor. Rather, the Court of Appeal balances the facts that are already found and then can draw its own legal conclusion de novo. But the facts are decided based on the record in the district court.
I assume that TUCO is the entity that drafted this contract. Why shouldn't we construe it against TUCO, given its ambiguities and the emphasis on royalty payments and the lack of control of the hours that Mr. White worked, and hold that against TUCO as the drafter of the contract?
Your Honor, this court should not even if this court does, in fact, view this contract in the light most favorable to respondent, which it did at the district court level when petitioner moved for summary judgment, it still is clear from the contract. It says works made for hire. It says employment contract. $100 a week was paid to Mr. White. He worked for 2 years for TUCO Comics. So even in the light most favorable to respondent, this is clearly an employment contract that controls the analysis. And looking to that contract first furthers the clear and predictable property interests that need to be defined in copyright. In addition, if there are concerns about provisions of the contract, the proper remedy for Mr. White would not to be to instigate this action, but would be to go to a state court and have an action on the contract itself. So here, really, the legal question is whether in a work for hire analysis, you should look at a contract first or look at the Reed factors. And the contract creates a clearer and better rule for both parties going into this in the future.
What's the significance of the 13th Circuit's discussion that White just summarized the agreement and signed it quickly because your company said he had to sign it to get paid first, and then secondly, he didn't have a lawyer review it. He was a lay person. He didn't understand it. What's the significance of that?
Your Honor, to the first point about the statements made by petitioner to Mr. White, while they did say this is legal stuff you need to sign in order to get paid, both of those facts are true. This was a legal document he needed to sign. He needed to sign the W-2. He needed to sign the contract to get paid. And Mr. White chose to sign both documents. And then as to the lack of legal representation, that's not conclusive here. Even if you construe this clear one-page contract in the light most favorable to the artist, it is an employment contract. Mr. White understood when he was signing this contract that he was giving up a copyright interest. Tuco Comics would not be paying him money if they could not use the drawings he made to publish them later.
Well, the 13th Circuit placed great reliance on the fact that he didn't understand it, but they only cited one district court opinion for that proposition. What case was that?
Yes, Your Honor. That case was, I don't.
Universal Music and Video, yeah.
Versus ULS.
And how is that case clearly distinguishable from the facts of this case?
Your Honor, the facts of that case are clearly distinguishable from the facts of this case because that was not a work-for-hire case. In that case, you don't have the interests you do here in a work-for-hire analysis where you want to be encouraging parties at the outset of the relationship to negotiate relevant contract terms. For example, in Reed, the court...
Well, actually, the only thing that was signed in that case were the tax forms.
Yes.
And that was signed much later after litigation was threatened.
Right, Your Honor.
So isn't that clearly distinguishable from a contract that's signed at the beginning?
Yes, Your Honor, and in that case, the party was told he had to sign those forms in order to instigate litigation.
In order to get paid?
Yes, in order to get paid. This court should continue to look at the employment contract here because this court in Reed, while not addressing explicitly what would happen if there was a contract in a work-for-hire analysis, emphasized that the parties in an entertainment context know that employment and copyright go hand in hand. When you're employing somebody to make things for you, and like you are with artists and in the entertainment industry, parties expect that copyright will be negotiated. This court stated that in a copyright marketplace, the parties negotiate with an expectation that one of them will own the copyright. At the outset of the relationship, the parties can agree on relevant terms, such as who owns the copyright. So here, it's a better rule to have this court making parties aware that at the outset of a relationship where a copyright is going to come up, that they need to determine who will be considered the author for a work-for-hire analysis, rather than doing a backwards-looking...
But if we looked at the agreement and we decided that it was more of a royalty or licensing agreement, we'd be making a decision about who owned the copyright as well. And then we would be telling the people who draft these contracts that they have to draft them more explicitly, and if they expect to have an employer-employee relationship, they have to monitor the work of the employee more closely. Why isn't that just as valuable a policy for us to pursue as what you're suggesting?
Your Honor, while that also would be clearer than at least the 13-factor test in Reed, to have the rule state that if it says work for hire, if it says employment contract, these are basic terms that the parties know going into the negotiation process have meanings as to who is going to initially own the right and the copyright. While it would be helpful to require parties to put in the contract part of the agency analysis instead, that rule still requires looking to multiple factors that different circuits weigh differently. The circuit courts have even stated that the Reed factors are often misapplied. There has been, this court would be better off if it instead allowed parties to look directly at the contract from the outset of the relationship and put both parties on notice to understand that if a contract says work for hire, then it means work for hire. And then the concerns that this court has raised about the imbalance in the bargaining process and other issues can be resolved through contract law. Common law has rules that provide protections for a person like Mr. White, but this court should still put the contract first and apply the contract law first before getting to the agency factors.
Well, if we don't do that, what's the circuit majority view as which of the Reed factors is the most important?
Your Honor, the Second Circuit in Ames versus Benelli listed 5 factors. I see my time has elapsed.
You may conclude.
Has listed 5 factors that it finds the most important. Tax, employee benefits, the control of the parties, as well as the skill involved and the length of the relationship. So
Yeah, and they said one of them was more important than the other four. Which one?
control, Your Honor.
And what's the authority for that?
The authority for that is common law agency typically looks to control first. And here,
But the Reed case didn't say that was the most important factor, although they discussed it first.
right, it said look to control as well as other relevant factors, and then listed
Exactly.
those. And here, Mr. White was in the control of Tuco Comics, and he was working as an employee in the scope of employment. This court should please reverse the decision of the 13th Circuit Court of Appeals. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Billy Cosmopoulos, counsel for petitioner Tuco Comics. When an author significantly contributes to a work, that contribution should be recognized in the form of copyright. Petitioner requests this court reverse.
Is significance enough, or does it have to be independently subject to copyright?
Your Honor, this court has never held that an independently copyrightable contribution is required for joint authorship. And petitioner is here to look for this court to create that bright line rule and say that it is not required.
Is that the majority view of the circuits that have ruled on it?
Your Honor, there are a number of circuits that have indicated that an independently copyrightable contribution standard be a useful analysis. However, none of those circuits have held specifically that an independently copyrightable contribution be required. The majority of those cases, for example, Childress versus Taylor, Erickson versus Trinity Theater, and the other courts that have talked about this, those cases rested on intent. The intention to be regarded as joint authors was the key factor. The independently copyrightable contribution.
Now, the district court did not reach this issue. Is that correct?
I'm sorry, Your Honor?
The district court did not reach this issue.
That's correct, Your Honor.
How is it properly before us?
This issue is only reached if this court finds against petitioner on the first issue. Mr. Pinkman
If it's not an independently copyrightable test, what bright line test can you pronounce for us? In other words, courts are used to deciding if something is copyrightable or not. What is the alternative test that you suggest we use?
The alternative test is the test adopted by the Seventh Circuit in Gaiman versus McFarland, Your Honor, and that test is the de minimis analysis.
We're giving such an important right to an author as to lead to the dispute here, right? The right to use the termination privileges after a period of time elapses.
Correct.
And we want everybody who has had any impact on the creative process whatsoever to have a participation right in that termination analysis? Is that the policy rule that you would propose?
No, Your Honor, it's not. The de minimis
What's
analysis.
the difference between that and de minimis?
The de minimis analysis, what is important to realize about that test is that it's not simply making a de minimis contribution. It's making something more than that. The Seventh Circuit in Gaiman and Professor Nimmer both define the de minimis test as an individual who contributes something that is more than insignificant, that is more than too trivial to merit consideration.
Are you conceding that if we do stand by the copyrightable test in Childress, that you lose the argument?
Your Honor, we do not concede that point. There is an alternative argument that Mr. Pinkman contributed sketches in the form of 3 pins that were adopted in the final Meth Men characters' costumes that could be independently copyrightable. However, petitioner looks for this court to clarify that an independently copyrightable contribution not be required for that joint authorship. Now, turning to the staff.
Does the intent portion have to spill over as well? In other words, if there's a de minimis contribution conceded, do we also have to look to intent, or is that enough?
Intent is certainly not enough. You need to do more than just.
No. My question is, if we find Pinkman made a de minimis contribution, do we also have to find that White and Pinkman intended to be joint authors, or does making a de minimis contribution by the rubric you would have us adopt overcome the intent requirement and put it aside?
Your Honor, 17 U.S.C. 101 defines joint work as a work prepared by 2 or more authors with the intention their contributions be merged into inseparable or interdependent parts of a unitary whole.
What is the evidence that White
The evidence at the record at 4 and 5 and 6 dictates that through the entire creation process, Mr. Pinkman and Mr. White both agreed that Mr. Pinkman's name would go on all of the promotional materials. The record at 6 indicates, it specifically says, that all the promotional materials said Meth Men by Walter White with contributions by Jesse Pinkman.
And it also, the record is quite clear, I think, that as far as White and Pinkman were concerned, White would get all the money. Shouldn't we follow the money?
No, Your Honor, not necessarily. Artists may not necessarily, and Mr. Pinkman may not necessarily, in this case, be concerned about getting the money for his contributions. All he wanted to do, and the record is clear on this fact, Your Honor, is that he wanted to be recognized for those contributions.
But that came after the fact. In other words, Mr. White had the right to refuse any and all contributions from Mr. Pinkman. It wasn't until after he accepted some of the suggestions of Mr. Pinkman, and he said, yes, I'll go along with contributions by Pinkman. So to follow your analysis that they kind of have an oral agreement really doesn't hold much water because that comes after the fact.
Your Honor, there's nothing in the record that indicates that the agreement to work together, the agreement to collaborate, came after the fact of the actual making of the comic book series.
So what is it? Is it an agreement? Is it an oral agreement to collaborate? Or is it just two old friends brainstorming ideas? And once the old friend that is doing the work says, I'm gonna take that, you should get some credit for this.
Well, Your Honor, the individual, that analysis does not come into play when it is a forward-looking analysis, Your Honor. It's not simply a backward-looking analysis. The House report from the 1976 Copyright Act says that a work is joint if the authors collaborated with each other, comma, or, and then it goes on to cite the statutory language that has actually made it into 17 U.S.C. 101. So the fact that both Mr. White and Mr. Pinkman had the intention to collaborate and to form their ideas and their contributions into, and I'm quoting the statute again here, an inseparable or interdependent parts of a unitary whole. And that is the intention that matters, Your Honor. Whether or not it's not whether they intended to be joint authors and be regarded that way under the law, it's whether or not they intended to combine their contributions into one unitary whole.
Counsel, I'm not an expert on comic books, but I can imagine a superhero's costume being changed, but retaining the same powers, the same mission statement, the same circle of dramatic allies and enemies in a comic book series without its fundamental character or the creative aspect of the comic book hero being altered. All Pinkman did was say, why don't you make that blue thing red? Why don't you make that yellow thing green? Is that really a creative enough contribution to reflect that it meets this test?
It absolutely is, Your Honor. And there are three distinct contributions that the record indicates that Mr. Pinkman made. First, as Your Honor touches on, Mr. White had the idea to have a team of blue superheroes. Mr. Pinkman had the idea to change the team of blue superheroes into a team of rainbow-colored superheroes, each with different individual costumes. Those individual costumes represent the individual's superpowers. The red superhero has the power of fire. Giving a blue superhero the power of fire does not have the same effect. The individual's colors represent those powers. Now, the second thing that Mr. Pinkman contributed is one of those powers itself. Of the 5 superheroes, Mr. Pinkman had the idea for one of those superheroes' superpowers. If you were to look at the Avengers, Your Honors, or any other team of superheroes, one of those individuals' powers, the Hulk, for example, that is a significant portion of that Avengers comic book series. And thirdly, the sketches that Mr. Pinkman drew became the logos for 3 out of those 5 superhero costumes. Now, those 3 things, a superhero is recognized not only by his costume, Your Honor, but also by his power and also by his logo. Superman would be nothing without his red cape, his incredible strength and X-ray vision, and the S in the diamond on his chest. Those 3 things are significant enough to pass this de minimis standard and should grant Mr. Pinkman joint authorship of that comic book series.
Well, Consul, you suggested that your client, Mr. White, simply wanted recognition. Isn't there a huge difference between recognition and intent to be a co-author? For example, if you wrote a law review article and you recognized an associate for some research assistance in footnote 1, that associate would not be a co-author, but that associate would be recognized. Why is that any different than the situation here?
Because for two reasons, Your Honor. First, that associate likely would not have met the de minimis standard. The important thing to recognize is not someone that merely makes a de minimis contribution. It's someone that significantly makes something more than de minimis that ends up really impacting the final product.
The research doesn't impact a law review article?
Well, Your Honor, research and ideas are not in themselves copyrightable. The court in Childress and Erickson and numerous other circuits have held this, and additionally, 17 U.S.C. 102B says ideas are not copyrightable. So ideas and research are not copyrightable. It would have been his minor edits, the research assistant's minor edits, that would not have met that de minimis standard, which is contrary to the individual impact that Mr. Pinkman's contributions had to this final meth-men product. And Your Honor, that fundamental unfairness that Mr. Pinkman would not receive joint authorship of something that his contributions really created and really did something that significantly granted audience appeal over the Meth Men comic book series for his costume, for the heroes' costumes, for the heroes' powers, and for the heroes' logos. Though that not awarding Mr. Pinkman joint authorship would be a fundamental unfairness just because he doesn't have something that is an independently copyrightable portion that, when examined separately from the Meth Men comic book series, is copyrightable. The Meth Men comic book series is a copyrightable work, and that is all that 17 U.S.C. 101 says. That unitary whole must be copyrightable. Nowhere in the statute does it say that the analysis should be to split apart the individual portions contributed by each person and examine the copyrightability of those portions. Additionally, as far as congressional intent goes, in 1987 and 1989, there were two proposed amendments to add this independently copyrightable contribution standard into the statute. And Congress rejected those additions and rejected those amendments.
What about the policy implications of the position you advance? Even a de minimis contribution of creativity can trigger a joint authorship. Aren't we going to lose the incentive for artists to corroborate with each other? If I'm Walter White and I'm listening to your argument, I'm not inviting Jesse Pinkman over to bounce ideas around. All the Meth Men are blue. Tuco Comics doesn't have $1 million seller anymore. What kind of incentives are you trying to get us to create?
Well, Your Honor, one thing that I really want to stress is that it's not just a de minimis contribution. It's something more than a de minimis contribution. But so in order to, that is not necessarily such a low threshold. In the extreme case, Your Honor, an independently copyrightable contribution standard could be a lower threshold. If someone comes in and merely produces something so minor that doesn't really have an impact on the final product, and that thing is independently copyrightable, then they would have joint authorship. They would significantly have a joint authorship claim over that final product if this court were to adopt that standard. But petitioner is here to urge this court to not adopt that standard and to adopt this de minimis analysis that will reward individuals who make significant contributions to a final product regardless of their contribution's copyrightability, Your Honor. Now, in addition to the statutory language and the congressional intent and this fundamental unfairness when someone's contributions are so inseparable from the final product, there's also another fundamental unfair situation that could occur if this court were to adopt that standard. And that is what the Seventh Circuit recognized in Gaiman versus McFarland. The Seventh Circuit indicated that because, due to the nature of the collaborative process, none of the individuals who contributed something to the final copyrightable product had an individual copyrightable contribution. And under the facts of that case, that fundamental unfairness would have been that no one would have gotten copyright over the final product if the Seventh Circuit and Judge Posner had decided to incorporate that independently copyrightable contribution test. Now, the question on page 3 for cert, Your Honor, is whether or not an author must make an independently copyrightable contribution to a work. And the answer is no, because there are two significant unfair situations that can arise if this court were to adopt that independently copyrightable contribution standard. Now, petitioner requests this court reverse the 13th Circuit Court of Appeals and hold that an independently copyrightable contribution not be required for joint authorship. Thank you.
Thank you, counsel.
Good afternoon, Chief Justice, Your Honors, and may it please the Court. My name is Hopi Costello, and I, together with my co-counsel, Amanda Meinhold, represent the respondent in this case, Walter White. I will argue that White's work was not made for hire, and my co-counsel will argue that Jesse Pinkman was not a joint author. This is a case—
Ms. Costello, how could Mr. White not understand he was an employee when he had Social Security withheld and FICA paid on his behalf?
Your Honor, this case is not about— well, this case is not entirely about what Mr. White understood himself to be. This case is about whether, as a matter of law, White was an employee. Under Section 101(1) of the Copyright Act, work is only made for hire if it is made by an employee within the scope of his or her employment.
So, Ms. Costello, if it's not about what he understood, then the fact that he just skimmed the agreement and signed it without the advice of counsel is irrelevant then in your view?
Not irrelevant, Your Honor. Under the Reed analysis, this court should consider what the parties understood their relationship to be.
Which Reed factor is that?
It is not specifically enumerated in the Reed case, Your Honor. However, in Reed, this court adopted all of the common law rules of agency to determine employment.
Is it the common law rules of the state in which the issue arises?
Your Honor, no. It is the common law rules of agency generally as they are enumerated across the jurisdiction.
How does that square with the Erie Doctrine?
Your Honor, the common law rules of agency, it squares with the Erie Doctrine because they are extrapolated across the jurisdictions generally. For example, in his treatise on contracts, Williston generally summarizes the rules in contract law across the jurisdictions. Similarly, the rules of common law of agency that this court adopted in Reed are a summarization of the rules of agency generally. One of these common law factors of agency is how the parties understood their relationship. While this court—
is a one-page contract. There's a paragraph, I think it's number 4, that says, anything you create is going to be a work for hire. Those aren't the exact words. You know them better than I do. What could be a clearer expression of their understanding than that? He signed it.
Your Honor, the parties' understanding of their relationship is just one of the common law factors of agency. In this case, there could be a clearer expression if the contract had explicitly said what work made for hire means. In fact, it is the industry norm for contracts to explain the term work made for hire. This can be seen by the fact that on numerous websites that collect work made for hire contracts, these contracts describe the implications of work made for hire.
Is that in the record?
No, Your Honor. However, this is publicly available knowledge and information, and this court can take notice of that information pursuant to Mueller versus Oregon. In addition, whether or not in this specific case the parties Mr. White understood the work made for hire contract or the contract in general is not the question. The question before this court today is whether, as a general matter, this court should look beyond contracts to determine in substance whether a person is an employee, or whether this court should look at form over substance and consider only an employment contract.
Are you familiar with the Ames factors from the Second Circuit?
Yes, Your Honor.
Where did they come from?
Your Honor, these factors came from the Second Circuit, and the Second Circuit extrapolated these factors by analyzing cases that came out between Reed in 1989 and Ames in 1992.
But of course, this court in Reed never said those 5 factors were paramount, did it?
No, it did not, Your Honor. In Ames, the court looked at what the other courts in the years between Reed and Ames, which factors other courts had held to be important. Because Reed has 13 factors, the Ames court wanted to try to extrapolate those down to the most important.
So how do those 5 factors help your client?
Your Honor, in this case, 4 of those 5 Ames factors suggest that White was an independent contractor. First and most importantly is the fact that White had nearly unfettered control over his daily work.
Well, how can you say that? White's original idea was he was working on a single superhero. Tuco comes to him and says, we want a team of superheroes. White changes track and goes from making one superhero to a team of superheroes. Isn't that the fundamental exercise of control over the creative process, to say what's to be created?
No, Your Honor, because in Reed, this court stated clearly that the control factor asks which party had control over the manner and means of production, the daily process by which the work is made, not which party had control over the ultimate product. In this case, White had control over the daily process by which he made his work. He worked from home using his own tools on his own time with his own friend who he asked to come help him brainstorm. This is stated at page 5 of the record. All of these factors show that White had a great deal of control, nearly unfettered control, over his daily work process.
So you're suggesting that when we have, in essence, what you're suggesting is a deficient contract. It's a contract that has too many gaping holes, that this court puts a new rule in place that basically says, when there's a contract that's not worth the paper it's written on, you should look at the facts that control the relationship of the parties, irrespective of what the contract named them?
Yes, Your Honor, in essence. The court can still consider the contract under the Reed analysis. Respondent's position is that the court should look to all of the factors of the employment relationship and not only the contract. In fact, this is what is done in many other areas of employment law. For example, under the Fair
Not if you find there's a contract, you never reach the Ames factors. The Ames factors, or the Reed factors. If there's a contract, those factors are irrelevant.
Respectfully, Your Honor, no. Under both the Fair Labor Standards Act and in the IRS context, the court looks beyond the existence of a contract and conducts a very similar test to the Reed test, which is judicially created to determine in substance whether the parties had an employment relationship.
But didn't Reed say if the court finds that there's an employment contract, you don't reach their factors?
No, Your Honor. Reed did not limit its holding in this way. It is true that in Reed there was no employment contract. However, the Reed court did not limit its analysis or its test to a situation where there is no contract. This court should look beyond the contract because only a contract cannot show which party had control over the daily process by which the work was made.
What cases did the Supreme Court decide on when they discussed the control factor as the first factor? There were 2 NLRB decisions from the Court of Appeals. What application does the NLRB have to the copyright statute?
Your Honor, the applicability of the NLRB is that in that context, the courts frequently have to determine whether someone is an employee. Similarly, in many other contexts, the courts also have to determine whether the person is an employee. And in all of these contexts, the court looks to control to determine if there is an employment relationship. For example, under both the FLSA and the IRS, and under the Americans with Disabilities Act, under Title VII, in the ERISA context, in the agency context, and under employment law generally, employment contract law generally, the inquiry is into which party had control over the daily process by which the work was made. In this case, the court should do the same. Whether a party signed a couple of documents does nothing to show who had control over the daily process by which the work was made. This court should instead conduct the Reed analysis to get to the substance of the parties' relationship.
How does the legislative history of Section 101 support your view?
Your Honor, the legislative history of Section 101(1) supports my view in a few ways. First, the legislative history of Section 101(1) shows that that statute was enacted in order to further protect artists. This was stated by the Second Circuit and Dumas versus Gomerman when summarizing all of the legislative history. Under the prior 1909 Act, artists received much less protection, and when Congress enacted the 1976 Act, they wanted to protect employees further. Therefore, they limited the work made for hire doctrine under Section 101(1) only to employees. In doing so, Congress recognized that work made for hire is a drastic delegation of rights. It gives up an artist's right to his work forever. Not only this, it does so before the artist has a chance to ascertain how much his work is worth. Therefore, Congress carefully limited the work made for hire doctrine to employees. Congress also left the term employee undefined. The Seventh Circuit in Gaiman versus McFarland explained that Congress wanted the courts to decide on a case-by-case basis who was an employee. If this court looks only to an employment contract, it will not be deciding on a case-by-case basis who is an employee. Only under the Reed test can this court determine, case-by-case, who is an employee. In addition, the legislative history supports respondents' argument because under Section 101(2), the types of independent contractor work that may be created as work made for hire are severely limited. If any work where an employment label is slapped on it can be made into work made for hire, Section 101(2) will subsume Section 101(1). This is not what Congress intended.
I want to ask you about the 11th Circuit holding. It's the same question I asked Ms. Zaret. On page 10 in the record, they say there's a material question of fact as to whether or not there's an employment contract, and in the very next sentence, they actually find that your client is an independent contractor. How do you square that?
Your Honor, the 13th Circuit stated that there was a material issue of fact as to whether this was an employment contract, but it went on to do the Reed analysis and to show that summary judgment was improper because a reasonable fact finder could find that Mr. White was an independent contractor. For this reason, the 13th Circuit reversed the district court's summary judgment grant.
So what relief are you asking for?
Respondent is asking that the summary judgment order be reversed from the district court and that this court decide as a matter of law that an employment contract is not dispositive to show employment. This court can also decide as a matter of law that Mr. White was an independent contractor because while each fact under the Reed analysis is a factual question to be determined by a district court, the weighing of these facts to determine whether they show an independent contractor or an employee is a question of law that this court can decide.
Did you cross-move for summary judgment below?
Your Honor, the record is silent as to whether respondent cross-moved for summary judgment, indicating likely no. However, the record is silent as to this point.
Well, I'm confused. You say it's a question of law. I thought the district court, if there was going to be a trial, would have to decide the 13 factors, or if it was a jury trial, the finder of fact would apply the 13 factors. You're saying that's a question of law?
Your Honor, the overall conclusion of whether someone is an employee or an independent contractor is a question of law, but each fact on its own under the Reed test, for example, whether the person worked from home, whether the person was provided with benefits, each of these is a factual question. The district court decided that no reasonable jury could find enough of these factors to suggest an independent contractor relationship, and this is what the 13th Circuit overruled, stating that a reasonable jury could in fact find that enough of these factors weighed toward an independent
And you're
contractor.
asking us to go beyond the 13th Circuit and say as a matter of law, these factors demonstrate independent contractor status.
Yes, Your Honor, because these factors were decided on a factual basis at the district court level, this court can now weigh these factors on its own and need not remand for a trial. However, if this court disagrees and chooses to remand, respondents still ask that this court decide as a matter of law that a contract is not dispositive.
So you want us to hold that an employer and an artist can never enter into a contract that makes the artist's work for hire, that always the court will be subject, the relationship will be subject to judicial review under the Reed or the Ames factors?
Yes, Your Honor, and that is consistent.
So nobody will ever know. A Tyco could offer $1 million to somebody to create something, and they won't know until there's a court challenge later whether it was a work for hire and they acquired the intellectual property rights, or whether they're going to lose them in a court battle over the Reed factors. That's the policy he wants to adopt.
Your Honor, the employer can know from the outset by deciding whether to treat the person as an employee or not. There have been years of judicial decisions on this since the Reed decision, And these employers, especially one like Tuco Comics, is likely to have a large legal department who can tell them how to treat someone as an employee so as to get their work. Further, this is what this court does in a majority of other contexts. This is the standard under the Fair Labor Standards Act and under the IRS, and this court should do the same under the Copyright Act. Employers can be sure that they will get intellectual property rights where they treat the person as an employee. This is because work made for hire is meant to be a bargain. The person gives up the right to their intellectual property rights, and in return, they get the benefits of employment. Thank you, Your Honors.
Thank you. Good afternoon.
Good afternoon. Chief Justice, Your Honors, and may it please the Court. My name is Amanda Meinhold, and I represent the respondent, Walter White. I will be arguing that Jesse Pinkman was not a joint author of the Meth Men series, and therefore Walter White's termination was valid pursuant to Section 203 of the Copyright Act. If this Court accepts petitioner's claim of joint authorship, it will open the door to corporations looking to use minor contributors as pawns to thwart artists exercising their statutory termination rights.
And if we render a holding that says someone like Jesse Pinkman in this factual scenario gets no rights at all, he won't come over to the house and help Walter make any creative advances. How do we balance that?
Your Honors, the independently copyrightable standard of joint authorship properly balances the interests of both major and minor authors because contract is always available for contributors such as Pinkman to determine in advance if they would like to have some ownership
Your
over.
co-counsel just told us to ignore contract law and rely upon real-world factors. Now you're telling us to ignore real-world factors and rely on contract law. How can we be consistent in ruling your client's favor?
Yes, Your Honor. Although these do seem inconsistent, in fact they are not, because the difference is, as my co-counsel argued, contracts are not need to be looked beyond specifically in the employment context, because this court established a 13-factor case-by-case analysis through the Reed test that applied to employment contracts. In the copyright context, by contrast, the goal of the 1976 revisions to the Copyright Act was to provide certainty and clarity of copyright ownership. In this way, it is more important for this court to set a standard that is easy to apply, that is easy for artists and courts to understand.
But don't we have to apply the plain meaning of Congress? And if Congress intended an independent copyright standard, they clearly could have said so in the language of the statute, and they did not.
Yes, Your Honor. The statute admittedly has never contained an originality requirement expressly. However, the statute does contain the word author. As this court has defined author, it means someone who translates an idea into fixed, tangible expression entitled to copyright protection, as stated in the case of Community for Creative Nonviolence versus Reed. There is nothing to suggest that this court's own definition of author should change merely where the word joint is added before it. And as my opposing counsel pointed out, there were efforts to amend the Copyright Act to include this language. However, those efforts may not have passed simply because the independently copyrightable standard is the majority standard in courts today and has been overwhelmingly accepted, including by the Copyright Office itself.
Is that a bright line test?
Yes, Your Honor. The independently copyrightable standard does set a bright line rule because courts in applying it can look to the Copyright Act for guidance. Courts in every circuit have familiarity with determining copyrightability, and the statute sets out plain requirements that are easy to look to. My opposing counsel posits that the more than de minimis standard is also a bright line rule. However, there is no definition of de minimis today, other than to just say that something must be significant or more than de minimis. It is not at all clear what this means. In fact, as Nimmer has described the de minimis standard, it merely means more than a word or line. This provides courts no guidance in the visual arts context, such as the case before us today involving a comic book, as to what de minimis could possibly mean and where that line should be drawn.
Do we have to reach that? Your adversary argued quite enthusiastically about the significance of the color and insignia of a superhero, and that's what Pinkman contributed. Maybe this is not the case for us to decide, because we do have a more than de minimis contribution. So much more than de minimis that it's independently copyrighted.
Your Honor, although color and pin sketches and changing superpowers certainly can have great importance in a work, and we've seen this play out in many comic books, that is not being disputed. However, in the case before us, there is nothing in the record to suggest that in this work, in the Meth Men series, the color had anything to do with audience appeal, the color had anything to do with making these characters more recognizable, and arguably a team of male superheroes dressed all in blue is just as distinctive as a group dressed in rainbow colors because they're instantly recognizable as part of a group. So although color and those types of changes can be significant, in this case there is simply nothing to suggest that they were. Jesse Pinkman, under the independently copyrightable standard of joint authorship, was not a joint author of the Meth Men series because he contributed nothing to this work that could be copyrighted on its own. First, his suggestions to change the color, to change a superpower, and to change the pin sketches of these characters are not copyrightable. First, suggestions, such as having to do with the color, cannot be copyrighted because ideas are not copyrightable, as stated by Section 102 of the Copyright Act. Further, Jesse Pinkman's pin sketches are similarly not copyrightable because they are not creative. As this court recognized in Feist Publications Incorporated versus Rural Telephone Service Company, a work must show a level of creativity in order to be copyrighted. In this case, Jesse Pinkman's pins are not akin to the Superman logo or the stylized Batman bat that have been changed in a creative way. His pins consist solely of generic images.
Well, White must have thought they were pretty important because he told Tuco about Pinkman's contribution. If White, the creator of the work, didn't think they were an important component of what he created, why would he have told Tuco Comics that Pinkman had a role to play in the development of his idea?
Your Honor, the record does not state exactly why Walter White felt he had to bring this up. However, this is a case involving two longtime childhood friends, as stated in the record on page 5. It could therefore be inferred that possibly White was just trying to be a good friend and wanted Pinkman to get recognized in some way, which he was in the final series. His bringing Pinkman up at the meeting did not rise to the level of saying, "This is someone who I feel stands on equal footing with myself." And actually, to the contrary, at this same meeting, Walter White presented the final version of the Meth Men series to Tuco without even showing Jesse Pinkman, as stated in the record on page 5. This is not behavior that would be typical of someone who had a 50% equal stake in the work with Walter White. Certainly, they would have at least wanted to have seen the final version of the work before such a huge decision was made to publish it as is. This gets to my second point regarding Jesse Pinkman and Walter White's intent in this work. Every circuit that has considered the intent required of joint authors has held that joint authors must intend to regard themselves as joint authors. This is because the intention to merge contributions, as suggested by my opposing counsel, is such a low standard that it is hard to even imagine someone that could not meet that threshold. If the standard is applied in this way, at such a low level, it will lead to a situation where every copyrighted work has hundreds, if not thousands, of joint authors. The Ninth Circuit addressed...
What's your basis for that statement?
Your Honor, the Ninth Circuit addressed this situation in the case of Al-Muhammad versus Lee. In that case, Spike Lee hired a movie consultant to work on his movie to ensure he was portraying Islam accurately. When that same minor contributor then tried to assert joint authorship, the court discussed how disastrous it would be if every minor party would be able to be successful in that claim. This is because there are so many people involved in the creation of a movie or a TV show that if the standard is set exceedingly low, many people are going to meet this standard and copyright will explode such that every work is open to who knows how many attacks of people trying to assert their joint authorship. The court in Al-Muhammad also discussed how such a holding would have a chilling effect on the creativity and collaboration that drives the arts forward. If that minor contributor were able to be successful in his joint authorship claim, Spike Lee and every other director going forward would never hire a consultant again, and the arts would be significantly poorer for that, to the public's detriment.
Well, Pinkman wasn't a hired consultant here. Doesn't your argument actually have an equal impact in the opposite direction? That is to say, if Jesse Pinkman is a comic book superhero creator in his own right, with his own valuable ideas, and Walter White wants to collaborate with him, why will Pinkman agree to collaborate if we don't protect his contribution?
Your Honor, Jesse Pinkman could agree to collaborate in exchange for other forms of recognition and compensation besides copyright ownership. For example, when editors make suggestions or people do the makeup on a movie, these people are still driven to collaborate, but they do not expect to own the copyright as a result. This is not a case, and respondent does not assert that Jesse Pinkman is totally undeserving or not worthy of credit in some way. He in fact was credited, as stated in the record on page 5, and he accepted money from petitioner. This is merely a case to establish that he does not deserve to have full copyright ownership, equivalent to Walter White's copyright ownership, as the person who spearheaded the creation of the series from ground up. In considering the intent of these parties, it becomes further evident that neither intended Jesse Pinkman would ever be a joint author. The Second Circuit has enunciated a test for measuring intent that looks to the objective evidence to truly glean what parties intended just beyond their subjective after-the-fact state of mind. These factors include the level of control or decision-making over the work, the parties' billing and credit arrangement, and third, how parties represent themselves to third parties. In applying these three factors to this case, Jesse Pinkman does not manifest intent in any way. First, it was Walter White that retained total control over this series. Yes, Jesse Pinkman was invited to collaborate, and his suggestions were used. However, it was Walter White that made the decision at his will to include these suggestions, to reject these suggestions, which he in fact did, as stated in the record on page 5. Further, Walter White and Jesse Pinkman did not represent themselves to Tuco Comics as parties with an equal share in this work. This is evidenced by the fact that Walter White presented this work to Pinkman without showing him, the fact that Pinkman was immediately willing to give up his rights in this work, and in this way they did not represent themselves to others as parties with equal ownership in this final product. Jesse Pinkman's pin sketches do not suffice to make him an author under this standard because they are generic, and generic symbols can never be copyrighted, as stated in the Code of Federal Regulations, Section 202.1. This serves an important public policy goal because it would be dangerous for parties to be able to achieve monopolies over these generic images such that no other party could use them going forward.
What weight is that CFR entitled to?
Your Honor, that CFR is entitled to weight because it references the copyright statute and the Copyright Office. As stated by the Copyright Act in Section 501, these regulations, as well as administrative documents from the Copyright Office, do carry significant weight because they represent a body of experience specifically dealing with copyright subject matter. To find that Jesse Pinkman is a joint author in this case would be to extend joint authorship to someone who has never claimed it in over 3 decades. This court should be particularly skeptical for that reason. Thank you.
Thank you. Rebuttal? Ms. Sarah?
A few points on rebuttal, Your Honors. First, respondent ignores the fact that Ames discusses that the Reed factors should only be applied if there is no employment contract. This court should hold that an employment contract with the provision that makes a work for hire establishes that that work is in fact for hire. This provides the certainty and clarity that the Copyright Act demands and that this court recognizes and respondent admits is a chief tenet of copyright law.
Well, the mere fact that you label something an employment contract is not dispositive because you can have an employment contract that establishes an independent contractor basis or a partnership or a whole bunch of different types of entities. So where in the agreement does it actually explicitly say that Tuco is the employer and that White is the employee?
Your Honor, it states that Tuco Comics agrees to employ Mr. White and that Mr. White agrees to be employed by Tuco Comics. But
not as an employee. He could be employed as an independent contractor.
The term
or a consultant or something else.
Yes, Your Honor, but the fact that it states that it's a work for hire, in addition, is the clear indicator here that he meant to be employed as an employee, and that provision.
Well, how is Mr. White supposed to know that?
Your Honor, because Mr. White is an artist who works in an area that deals with copyright, and when he's negotiating the terms of an employment contract, as this court stated in Reed, he goes into it, or any artist goes into the negotiations with the expectation that copyright will be part of the negotiations.
So if you were a college student and Tuco found a cartoon he wrote for his school newspaper and gave him this contract, we should analyze it differently?
No, Your Honor, this court should still look to the contract and apply contract law first. Now, when district courts are deciding these issues, they can weigh these facts, but the important law that this court needs to announce for all courts to follow is that contract law and the contract governs work for hire. Thank you.
Thank you, counsel. I thought they reserved some time for second counsel. Oh, okay, thank you. Okay, we'll take the case under submission. Normally we conference on Mondays, but we're going to conference a day early. And we'll be back with our decision. Thank you very much. Take the case under submission.